Good afternoon, everyone. Welcome to the Appellate Division First Department. According to this, we have 4 hours of argument time requested, so that would take us to 6 o'clock. So I apologize to whoever that last group of attorneys would be for argument, because you'll be here till 6, which is not going to happen. So you know the spiel. Ask for the time that you believe that you need to present any cogent and arguments which we may not be aware of. Keep in mind that we have read your briefs. We are aware of the arguments. If, give you set one time and we need additional time because we have additional questions, we will certainly proceed. People v. Michael Stewart. 5, 2, and 5. Desser versus Pascal. Hello, Desser v. Pascal. Oh, is that you? Okay, so who are you? And how much time would you like?
4 minutes.
Okay. Did you want any time in rebuttal or no?
4.
Okay, and go ahead. 4, 2, and 4. WK Children is submitted. Capitas Servicing versus MS Health is submitted. People v. Lloyd Parks is submitted. Pineda versus 525 SMA. I don't see a respondent. Would you like to submit? Submitted, thank you. Go New York Tours versus Tour Central Park. 6 and 2. Go New York? 5, 2, 5, and 2. Camco Supply versus Nastasi and Associates. 5, 2, 5, 2. People v. Jamar Carr. 5 and 1 and 5. Banks v. New York City Transit Authority. 5, 2, 5. Geronimo versus Guzman. Submitted. Filardi versus Roman Catholic Archdiocese. Is there a respondent? No? Submitted. Thank you so much. Board of Managers versus 13th and 14th Street. Submitted. People v. Michael Stewart.
Good afternoon, Your Honors, and may it please the Court, Barbara Zolot for Appellant Michael Stewart. Your Honors, the trial court erred here in summarily denying Mr. Stewart's 440 motion asserting defense counsel's ineffectiveness for failing to move to dismiss the indictment based on the approximately 22 years of pre-indictment delay. At a minimum, a hearing was necessary to determine whether the investigative delay here was justified. Now, the hearing court's conclusion on the papers that the delay was justified because the prosecution and law enforcement needed more evidence to arrest and prosecute doesn't answer the question of good cause here, because law enforcement didn't do anything to acquire more evidence, certainly in the period after 1995, and very minimal efforts even before then.
And this was not sufficient to be done on papers? The submissions?
Correct.
Why
Correct.
is that?
The need for more evidence may be a valid reason for delay, but due process and the associated case law establishes that there must be something done during that period.
What is the issue on which you feel there needed to have been an actual evidentiary hearing?
Yes, the precise issue is what the law enforcement could have done, what investigative tools were available to them in that period when we didn't have today's computerization, that would have at least shown efforts to locate Mr. Stewart or
But I
acquire
thought that that was,
information.
I thought that that was discussed in the papers submitted by the people in terms of, I thought he had used different aliases. I thought he had also absconded to Jamaica for a while. I thought there were other issues that were brought out as to why the people were unable to proceed during that period of time.
The people never sufficiently answered that to negate the need for a hearing. Yes, he used an alias, but what's significant is that the law enforcement knew of that alias by October 7th, 1993, and yet they didn't pursue any further investigation knowing the alias. And yes, it's true that Mr. Stewart flew to Jamaica September 20th, which was the day of the crime. But again, what's significant is that he returned 2 days later under the alias that law enforcement learned about just a week or two later. And yet there's no evidence, and this is why we need a hearing, it underscores the need for a hearing. We have no information as to whether or why law enforcement didn't do any follow-up knowing the alias, knowing Mr. Stewart's NICID, knowing Mr. Stewart's FBI number.
So he had been incarcerated for a period of time, for a period during this time, right?
He was incarcerated. In fact, he was incarcerated at Rikers, and yet we don't know whether or why the law enforcement wasn't able to follow up there.
And that was under a different name, right?
No, that was under Michael Stewart. And in fact, he was returned, yes, it was
So
under
when did he use Kenneth Hall?
Kenneth Hall he used when he flew to Jamaica. That was on the flight manifest. But again, law enforcement learned of this alias a mere 2 weeks after the crime, and yet there was no further follow-up conducted. So once again, while the need for evidence may be a valid reason for delay, there has to be
So
some...
the hearing that you're stating was necessary would have been the police officers, the detectives testifying as to
what investigative tools were available to them and why or why not those investigative tools could have been used to locate Mr. Stewart in that 22-year period. I mean, we know the prosecution said, well, we didn't have computerization then. Fine, but what was there? There were phones, there were fax machines. Were those resources capable?
who are you going to fax? I'm just curious.
I actually
Who would you fax? I don't know who are you going to fax?
Well, for example, Kings County, you know, I mean,
Why Kings County?
Well, because he was returned to Kings County Supreme
How would they have known that?
My point is that had they made efforts to put out information that they were searching for this person through analog methods, and we don't even know what computerization was available at the time, it may have been possible to locate him at an earlier point. My point being that while a need for evidence is a reason, there needs to be a showing that that some efforts were made to acquire evidence. And this court's decision just yesterday, if I may just make this one last point, in People Against Evan Wald, I provided it to the court and to my adversary, really supports this distinction because there was a 21-year period of delay, but this court noted critically that during the ensuing period, law enforcement and the prosecution conducted further forensic testing and re-interviewed witnesses. So efforts were made. The prosecution didn't just sit on its hands waiting for the evidence to magically apparate.
Thank you.
Thank you.
May it please the court, Vincent Revelisi for the Bronx District Attorney.
So what was before the court in terms of the pre-indictment delay?
What in terms of,
What information was before the court so that the court could make a determination as to the pre-indictment delay?
approximately 100 pages of motion practice and all of the trial testimony that was cited during the motion practice and the parties' arguments about the 5 Taranovich factors. What I would like to actually remind the court is that because it's an ineffective assistance motion and not an actual Singer motion, we don't really know the trial attorney's position as to why she didn't want to bring this motion. She said she didn't believe that the facts bore it out, but she also could have had strategic reasons for not wanting to take the chance. If she wasn't certain she'd win the motion, and there certainly are arguments on both sides, she could have created the need to present all kinds of evidence about the defendant's flight, about his aliases, about his time in Connecticut, living for decades under an assumed name. And that would not necessarily have helped his trial case had he lost the Singer motion. She did get a mistrial on her first trial. She might have felt that her best chance was to try to get a mistrial or an acquittal. So there are strategic reasons.
I'm not sure I follow that, because who would have the burden on that motion? And she could set forth whatever she would feel was safe to set forth, and then leave it to the people to have to refute it.
Well, she might have felt that if she didn't set forth everything, in addition, besides the fact that the people could bring in their own evidence as to the defendant's situation while he was on the lam, or whatever you want to say, living in Connecticut under an assumed name, she might not have wanted that to become front and center of the argument as to whether there was a Singer motion available to her. The people could have done additional investigation as to why the defendant was evading detection. So it wouldn't necessarily have been to her benefit to make that issue be front and center if she thought she had a good chance at winning the trial, and maybe wouldn't win the Singer motion anyway. There's plenty of case law for 20 years, 22 years. If the prosecution has a reason, as here, that they didn't think they had enough evidence when they first found that the crime committed, they thought that they didn't have probable cause. They didn't necessarily think they had proof.
What was the prosecution doing over all of those years?
Well, in the very beginning, they were looking for him. And then after they had the sense that he wasn't to be found, there wasn't a whole lot of else to do. This court has said in People v. Almonte, I believe Your Honor sat on that panel, but it was about 12 years ago, that the people are required to take reasonable investigative steps. But the people are not required to do everything. Could they have gone to every state and looked for every Kenneth Hall? They didn't know he was in Connecticut when he left in 1993. First, he went to Jamaica. When he came back from Jamaica using Kenneth Hall, they didn't know the alias yet until a couple of weeks later. Everything wasn't as computerized, so they weren't getting an automatic ding every time Kenneth Hall did something. And in addition, the wanted card that was available to tell police that Kenneth Hall was wanted to speak to was not an arrest card. There was no indication that he had been identified or that they wanted to arrest him or to put a hold on him.
Yeah, I'm not understanding your argument in terms of the ineffective assistance of counsel. If there's a 22-year pre-indictment delay, why, as a defense attorney, would you not make a motion to dismiss based upon that 22-year delay? I mean, I don't understand your argument about, well, the defense attorney didn't want to show her cards or, present certain evidence. That would have nothing to do with the trial itself.
Well, if she felt that by bringing the motion, the people were going to be motivated to try to present evidence about defendant's forged documents, his aliases, perhaps there were additional aliases.
For purposes of the hearing, not for purposes of trial. The jury would not be made aware of any of this. This would be a Singer hearing. It would be a separate hearing. It would not have anything to do with the trial itself.
Well, I would think a lot of that would be admissible as consciousness of guilt if he's trying to evade prosecution for the crime. When you see him interviewed by the police officers in 2015, he's certainly very evasive with them. He gives no indication what his true name is, even during that interview.
Again, that would be a determination made by the trial judge after the hearing, if in fact the indictment were not dismissed because of unreasonable pre-indictment delay. Then the trial judge would make that determination concerning consciousness of guilt. I thought there was a determination by the trial judge in terms of consciousness of guilt. Wasn't there testimony allowed that he had gone to Jamaica the following day?
Yes, definitely. And of course, if the defense attorney did bring the motion, it still wouldn't be an effective did not bring the motion and chose not to. It would still not be an effective assistance if the motion is not going to prevail. And that's obviously the bulk of our argument, is that the motion should not have prevailed. And Judge Marcus wrote a very informative 13-page decision. Of course, Your Honors will have read that. And it cites all of the Trinovich factors. And we ask Your Honors to affirm.
Thank you.
As to possible strategic reasons, that really doesn't make much sense. I don't see how it could ever not benefit one's client to move to dismiss.
Yeah, but while I join Judge Weber in having, not understanding the first of the Assistant District Attorney's arguments for not making the motion, but the second point of, you're talking about a pre-People versus Reagan law situation and a homicide case with the defendant not being incarcerated. Does defense counsel, and considering the strength of the people's case here, it may be circumstantial and all that, but it's a strong enough case, do you expect to win that motion?
Well, that really is the question. A hearing was necessary before Judge Marcus could conclude that the motion would not have been meritorious, which would be the only reason why counsel was not ineffective. And here, we need a hearing for that determination to be made.
Let me put it, wasn't it a reasonable decision by defense counsel to say, look, I'm not going to win this motion, so I'm not making the motion?
No. That would not have, that's our very point. That's not a reasonable decision.
Well, again, pre-Reagan, you looked at cases and you saw that a 21-year delay was deemed to be reasonable. 14, I think it was a 14-year delay in one case. I think I presided over a case where there was a 15 or 17-year delay, and all of those instances were upheld. So again, as a defense attorney, it's, why would I go through the exercise of making this motion, wherein most of the cases support, if not all of the cases, support a determination that this pre-indictment delay was reasonable?
Well, there is case law that says that the question of good cause, Reagan addressed a number of issues, and we would submit it supports our case strongly. But the issue of whether there's good cause and the question of whether there's adequate explanation for an investigative delay, that hasn't changed. The issue has always been, and I point your honors to People against Andine, which is a case from this court, 1995, cited in our brief. While again, the need for evidence may be a valid excuse and has always been a valid excuse, it must be accompanied by some affirmative, diligent efforts to acquire that evidence or exhaust reasonable efforts to do so.
So was there an affidavit by the defense attorney submitted as to why he or she did not submit not move for dismissal?
We made efforts to obtain an affidavit. Defense counsel was unwilling to provide one, but did provide us with an email, which in fact suggests that this wasn't strategic at all. She said, it's true, I didn't feel the facts supported it, but then she referenced this is a constitutional speedy trial motion, which does suggest, and again, a hearing would flesh this out, which suggests that defense counsel was confusing constitutional speedy trial, which would look at a different period of time, from pre-indictment delay. And there are at least one important factor that differentiates the two, which is prejudice. In pre-indictment delay, there is no requirement.
But it sounds like she didn't think she would win the motion.
Well, there are different ways to interpret it. It sounds as though she thought we were complaining about her failure to bring a different motion, not the Singer motion.
Thank you.
Thank you.
Desser v. Pascal.
Your Honors, may it please the Court, I am Stuart Desser. I am the petitioner appellant. I'm here per se, so if it's okay, I'll refer to myself in the first name. I requested time mostly to try to answer any questions you might have, but I would like to take a minute to make a couple of points if I could. The first is that both sides of this case agree that this is not a FOIL denial. This is not the appeal of a FOIL denial. Only the court below believes that's what it is. Yet the agency's brief on 2223 tries to distort the record by claiming that what the court below really said was that this should have been a FOIL request that was then appealed. That's what the respondent agency wants in order to send me back to zero. That's not justified in law, and that would be an exercise in futility. The second point is that no one, not DHCR, not the COOG, and not the court below, claimed that the information I seek and which they refuse to give me is not necessary in order for me to create certain effective FOIL requests. All they say is it doesn't matter because the regulation mandates nothing more than the vague and nonsensical information that they did give me, despite the wording of the regulation that mandates an agency aid me if necessary and when appropriate. They don't know what's necessary because they refuse to confer with me, and the most they claim is that the information they provided will, quote, facilitate.
Where are you finding the authority that the regulation requires them to give you databases? Where is that argument coming from?
It's from the language of the regulation
Where
itself.
in the regulation does it say that?
The regulation says that they must assist persons explaining how records are filed, retrieved, and generated. The way a record is filed is, in the case of a database, the fields, and the way it is retrieved is by the search engine. You know, there's no other way, I think, in this context to interpret that.
Yeah, but didn't they respond to you, the inspector, the attorney, Lance? Didn't he or she respond to you stating that how you needed to make the request because of the way in which they stored the material and tried to assist you in terms of honing down your request?
What he gave me is extremely vague and actually nonsensical information. Let me just read you.
He said provide relevant docket numbers, dates, names, addresses, descriptions, etc. He also sent you a web page with suggested language. He also stated to you should avoid broad descriptions such as documents containing a phrase or reference material because they don't maintain or characterize information under those statistics.
Yeah, and you notice the word statistics seems out of place, and it's not clear what reference material is. But much more significantly, if they tell me I can search by dates, they don't tell me which dates I can search by. Is that the date of the complaint, the date of the resolution, the date an inspector was sent out? How many different date fields are in the record?
Mr. Desser, just by way of an example, let's say, I don't know, it's not clear from the papers whether this data or this information was for you personally, but let's say you wanted to get information on a building. So you would use the various different topics to get that information. Like you would look for whether there were rent overcharge complaints. And hopefully the client you retain, if you're representing the tenants, would give you information about complaints filed, by way of example. And that complaint would have a docket number, an index number, and then that would lead to getting information on the dates, et cetera, referable to that building. I mean, the information you were asked to seek is based on reasonable topics. The Division of Housing doesn't have a database like Lexis or some of the other sophisticated law bases where you type in a code word and all kinds of cases spit out. It's not designed to do that.
No, Your Honor, it's not.
So that's why I'm stymied by what you were trying to search here. I mean, if you're looking for all kinds of information on a particular building, you would supply the address, et cetera, and somehow, given different topics, major capital improvement applications, hardship applications, rent overcharge complaints. I mean, they pretty much laid it all out for you. So it's unclear what you were seeking here.
Right, and you'll have time on rebuttal, but let me just say that was something that Lance told you in an email. He stated in the email the 22 complaint categories under the heading, and as my colleague just mentioned, rent overcharges, service reductions, et cetera. But you will have time on rebuttal.
Thank you.
Good afternoon. I'm David Lawrence III. I'm an Assistant Solicitor General on behalf of Respondent. This court should affirm the decision to order dismissing the petition. Importantly, it's well established that mandamus is available to enforce only a clear legal right and not a matter of agency judgment or discretion. Here, petitioner is not entitled to mandamus because the agency fully complied with its obligations under 21 NYCRR section 1401.2b2. That regulation requires an agency to assist a person in seeking records and indicate the manner in which the agency files and records are stored and retrieved. DHCR did this by providing a list by subject matter of the records. Also advised him to describe the records as specifically as possible. Said you should ask for records by name, dates, addresses, building numbers, descriptions, not phrases, because that's not how
Well,
agency stores its records.
Mr. Dresser is questioning what dates. I mean, you state you should provide the dates, but he doesn't know what dates you're referring to.
The information that DHCR provided to Mr. Desser is more than adequate to make virtually any FOIL request. If Mr. Desser, he gives an example, a very abstruse example in his brief. Pages 10 to 11 of his brief, he says he might want to seek all records of complaints against landlords for failure to provide required services to rent-regulated tenants where DHCR has dismissed the complaints only because the violation is cured before DHCR's inspector arrives to observe it. If he wishes to make such an abstruse request, it's incumbent upon him to make the request. If necessary, a court could then someday evaluate, well, in the context of that particular records request, was DHCR's information provided sufficient? So here, petitioner's Article 78 proceeding is premature because he has not made such a FOIL request. Furthermore, the regulation itself renders compliance with it a matter of agency discretion and judgment as to how it complies. It talks about providing information and assistance if necessary and when appropriate. That takes it out of the realm of mandamus. It's also important here that the Committee on Open Government opined that the manner in which the agency complied with the regulation at issue. That's important because the Committee on Open Government is a watchdog for open government. It has no stake as to which party prevails in a dispute between DHCR and Mr. Desser. So its impartial opinion as an advocate for open government should be entitled to particular deference. Petitioner's argument that the regulation requires the agency to provide more information is also not supported by the plain language of the regulation. If the committee had wanted DHCR to, or any agency to provide more detailed or particularized information, it would have specified so in the regulation. I see that my time is up.
Yes, thank you very much.
Thank you.
I'll try to answer your question first. So the example I give in my brief, which is an actual request I want to make, is that the agency has a policy of not holding an owner, a building owner, responsible if the agency doesn't get an inspector out before a violation is corrected. If a violation is corrected more than 1 month later, but less than 4 months later, that means the violation went on for a while, but it was not, the owner was not held to account. I want to know how frequently that happens. The way to know that is to know when the date that the complaint was made, the date of the inspection, the date that the case was closed, for instance. So that's just dates. We don't know which of those dates are separately in the record so that they can be searched by column by that date. It may be in a text field someplace, but if we search for dates by text field, we'll get tons of irrelevant records. So that's why this is different than searching in Lexis. In terms of mandamus, the requirement of the regulation, 1401.2b2, is to assist a person if necessary. This is exactly the same thing that happened in Brock's Defenders. They don't know what was necessary. They didn't hear the example that I just gave you because they wouldn't talk to me. So yes, it's true that that there may have been some discretion or some judgment when they had to decide if necessary, but they never got to that point. So the mandamus, the mandate rather, is that they consult with me. If they want to then say it's not necessary, then that becomes an arbitrary and capricious question, because I think I've demonstrated that it is necessary.
Thank you. Thank you both.
Thank you.
Go New York Tours versus Torque Central Park.
Good afternoon, Your Honors, and may it please the Court. My name is Eleni Melek with Perdal Senochavica, and I represent Appellant Tour Central Park Incorporated. The question presented before this Court is whether an enforceable settlement agreement was ever formed between the parties, and the answer is no. In similar situations, this Court has looked at the specific details in the documents, but also the totality of the circumstances. And here, the totality of the parties' conduct and the objective manifestation of their intent show that the parties didn't intend to be bound by the term sheet.
Counsel, you would agree that both sides were represented at the mediation that led to the settlement, correct?
Yes, Your Honor.
Right, so that means your client was there, your adversary's client was there, lawyers were there, they were all in a room with the mediator the second time around because the earlier mediation didn't work well. And at the second mediation, at the end of the day, the various terms in the agreement that you claim was not an agreement yet, but an agreement to agree, those terms were clearly understood. There were about 5 of them in there. You know, you can't use our trademark names. We can use rent bike, bike rent, and one side has to pay $10,000 to the other side, and 2 other terms that I didn't memorize. And then there were a series of emails back and forth in the record, correct?
Yes, Your Honor.
And these series of emails between counsel, where parties were all CC'd, copied, made it very clear we have a deal. There was nothing like, and at least if there's language in here, tell me in the record, oh, we must wait for a formal agreement with all the bells and whistles on it, and that we see for that to be a deal. Did you see anything like that in the record?
Your Honor, no. In the emails, there is no such language. However, the parties included qualifiers such as subject to the execution of a formal settlement agreement.
Counsel, don't we have a number of cases that say that subject to language is not enough by itself to be an express reservation of rights? It has to be something more than just mere subject to language.
And let me point you to Bed Bath & Beyond versus IBX Construction, as well as in the matter of Philadelphia Insurance Indemnity Company. 2 cases where both cases where we held that subject to, as my colleague just stated, there had to be more, and we would hold these that there was in fact an agreement.
Yes, Your Honor, but these cases are different from this case. For example, in Bed Bath and Beyond, there was a letter of intent, which is not quoted in the opinion, but the plain language of the letter manifests that the parties intended. The parties intended to be bound, and in Bed Bath and Beyond, there is partial performance according to the agreed terms. However, here, we don't have performance, and the court should look at the letter.
Who is it here who wanted to have a more formal settlement? Was it plaintiff or defendant who, because you had this email which set forth the terms, and then there's this, let's have a formal settlement. Who is it who wanted the formal settlement? Wasn't it the plaintiff who wanted it?
Your Honor, I believe that it was a mutual understanding that there was a need of a
But
formal
who made the
settlement agreement.
request for a formal settlement?
I am not aware because I wasn't the attorney representing appellant at the time that the mediation took place. However, I would like to point out that 2 days after the mediation conference, the parties submitted a joint letter to Judge Caproni, and there they made reference to a term sheet that contemplates the execution of a formal settlement agreement. There, the parties, because it was a joint letter, so both parties agreed on the language, they requested.
Well, the letter to the judge stated that the parties had participated in mediation and that they were able to reach an amicable resolution of this action. And it went on to say that the parties had agreed to a term sheet at the conclusion of mediation that contemplated the execution of a formal settlement agreement and subsequent discontinuation of the action.
Yes, Your Honor, but in the last sentence, it's a clear understanding that the parties had the expectation that the settlement would be finalized. So their understanding was, as the language of this letter shows, there was an understanding that the settlement wasn't final and something more had to happen in order for this term sheet to be enforceable, and that was the execution of a formal settlement agreement.
That portion of the letter to the judge that stated that the parties contemplated the execution of a formal settlement agreement? Is that what you're referring to?
In that regard, the party respectfully, request that this matters status conference scheduled to be held on November 20th, 2020, be adjourned to December 4th, 2020, with the expectation that the above settlement will be finalized in the interim and the action discontinued. So here, a plaintiff and namely respondents, did not proceed to the dismissal of the case. Instead, they requested an adjournment because they had identified the need for a formal settlement agreement.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court.
So is that how we should read that? The parties requested that the status conference scheduled for November 20th, 2020 be adjourned to December 4, 2020, with the expectation that the above settlement will be finalized in the interim and action discontinued.
Absolutely not, Your Honor. That agreement, which was composed by, it was a joint letter, but it was sent to the court by counsel for the appellant. And in that letter, he represented to a federal district court that the parties had reached a settlement. He knew that based on that letter, the federal district court would have to take action in the federal case. And the action that the court took, in fact, was to dismiss that case rather than postpone the case for a conference.
So that dismissal, was that communicated to the parties? Because on November 2nd, 2020, the judge entered an order dismissing the action with prejudice. The notice of dismissal reflected that the action was being dismissed because the parties had notified the court that they have reached an agreement in principle resolving all issues. Again, in principle, does that mean, again, that we are talking about a final settlement?
Your Honor, the court clearly understood correctly that the parties had reached an agreement on all material terms, and the court so informed the party. When the court dismissed the case, there's an automatic notification system in federal court, and each side received notification that the case was dismissed.
But does that catch an agreement in principle resolving all issues? Does that lead one to believe that that there was no final agreement?
No, all issues were agreed. Of course, it was subject to the routine documentation that we see in all types of cases where we have to craft releases and so forth. But, appellant says, well, there are all these missing provisions. There's so many things that still were left to be agreed upon. That's just not so. They're kind of speculating on other possible provisions that could have been part of the settlement.
Actually, it doesn't sound like there are provisions that weren't agreed upon. It sounds like there's a provision that someone had second thoughts about after having agreed to it.
I think that's exactly right. I think there was an agreement. I think it was clear as a bell. And I think the appellant had second thoughts and tried to back out of it. But there's a matter of public policy. Mediations save money. They're important. They're important for finality. They're important for saving scarce judicial resources. And here we have a case in which the fundamental basic terms of a settlement were absolutely clearly set forth before the mediator and with all counsel's agreement in a writing. And that was a writing that we think is enforceable. May I just make one other point? There's an argument that we see in the briefs that somehow the only purpose of this settlement was to avoid consumer confusion. That's not the case. Another purpose was to settle the issue of genericness. These were trademark cases. The allegations were made that some of these trademarks were generic and descriptive. The sole purpose was not to avoid confusion. Indeed, it was understood that to the extent some of the terms were generic, some confusion was unavoidable. That's why the settlement was crafted as it was. It was a fair and complete resolution of the issues before the court in the federal trademark case. With that, Your Honors, I can defer. I can wait for rebuttal or defer to any questions you may have.
Thank you.
Thank you.
Your Honor, regarding what Mr. Najas knew when he drafted the letter, I think this is a question of fact, and it wasn't addressed from the lower court. We respectfully disagree that all material terms were included because here we have two competitors in the same niche industry of bike rentals, and in this case, a settlement agreement had to include certain additional terms on how the parties can navigate their rights by using the exact same terms.
But as my colleague mentioned previously, this was a settlement agreement that was agreed upon and drafted by both attorneys for both sides. Both sides were properly represented. So this was the end result of that negotiation. So now how are we going to state that there were additional terms, provisions, et cetera, which was contemplated to be included, when this is not what it says?
Yes, Your Honor, this is not something that it's indicated in the email, but during the negotiation of a settlement...
Well, there is an open issue left after the first email, which is when the $10,000 is to be paid. So plaintiff's counsel, Ross, responds to the settlement email by saying, this is fine on condition that the parties complete documentation and payment is made within 30 days, to which Nahas responds by saying, yes, I agree. So what issue at that point is left for resolution?
Then Naha sends the settlement email to his co-counsel and client stating the case was settled.
Yes, Your Honor. At the time that the mediation took place and immediately after the mediation, the parties didn't identify this need to have further clarifications on the term sheet. However, the parties agreed, to proceed with the second mediation in order to clarify the third term, and that was exactly the reason, the purpose of the second mediation, to clarify how the parties are going to use simultaneously the same identical marks, regardless of whether they are generic or not. This is something that is not relevant for this case. However, the respondents did not immediately move to reopen the case or initiate an action because the parties identified the need to clarify how they are going to use these terms.
So was there any continuing discussions between the parties as to this has to be clarified, this has to be clarified, this should be put in, anything like that?
This was addressed during a conference with Judge Coproni. Not we don't have email communications on the record.
Thank you.
Thank you, Your Honor.
I'd like to make one important point here. What happened at the end of the mediation is there was an agreement by counsel and the mediator that a settlement had been reached. And then counsel for Go New York said, we need to make sure that we get this done quickly because my client wants that $10,000 and we don't want to wait forever. We need to get this done quickly. And counsel for the appellant said, yes, indeed, we agree, we need to get this done quickly. That showed an intent to be bound, not an intent not to be bound. There was clear evidence by the conduct of the counsel and the mediator that the parties intended to be bound. There were no discussions after the mediation concerning any confusion because there was no confusion concerning what those terms were. There was never a discussion either between the parties or otherwise about how we can fix the agreement. That never happened. The agreement was clear as a bell. So, Your Honors, I respectfully submit that Judge Bannon very carefully reviewed the record, and some deference should be paid to her. She did a very good job reviewing a very complicated record. There were deposition transcripts and so forth, and I think her opinion should be affirmed.
Thank you. Thank you both. Camco Supply versus Nastasi and Associates.
Good afternoon, Your Honors. May it please the Court, my name is Manny Frade. I'm from Meltzer, Lippy, Goldstein, and Brightstone, representing the appellants J.T. Megan and Liberty Mutual. Black letter law in New York that no lien can exceed the amount owed by the owner to the general contractor. That is, again, black letter law. The lower court here, however, determined that no, when it comes to suppliers, their lien can be subject not only to, it would be either to what the owner owes the general contractor or what the general contractor owes the subcontractor. That, however,
The Supreme Court relied on the fact that Megan owed money to Natasi.
I'm sorry, Judge?
The Supreme Court, to reach its decision, relied on the fact, just on the fact, I should say, that Megan owed money to Natasi.
Correct, Judge, which is an error of law, because a mechanic's lien attaches to real property.
Counsel, I should have maybe looked at the record more, but was a summary judgment motion made on this issue? Since your argument basically can be Your argument can be decided as a matter of law. Why did there even need to be a trial?
Well, there was a summary judgment motion at some point much earlier in the case, but this was a trial
Was that
that
argument made as part of the summary judgment motion?
there was a summary judgment motion in
That
which,
there was no money owing from the owner, so therefore there could be no valid mechanics lien.
correct, the motion at the time was denied on other issues of fact regarding the payments and what was due and owing. The motions were denied completely. And so we had the trial, and the plaintiff made absolutely no effort to show that there was money due and owing from the owner to the general contractor. That should have ended the case, irrespective of whether J.T. Megan owed money to Nastasi, because again, the lien rights are governed by principles of subrogation, and you can only have the lien rights that the party above you has. By holding that it's irrelevant, what the trial court did was to grant the supplier more rights than the subcontractor would have had. And here, not only, in addition, Your Honor, that wasn't the trial court's only error, because although that should have ended the case, the fact of the matter is that there was no proof that J.T. Megan owed money to Nastasi. The parties entered into a joint stipulation of undisputed facts, and one of those facts were that the records reflect a payment that J.T. Megan had paid Nastasi $6.9 million of the $7.1 million owed, and had paid the balance to a completion contractor because Nastasi had abandoned the project.
So what was the basis for the court's determination that there were monies owed?
Well, what the court held was that a lay witness's opinion, who was an employee of the plaintiff, had testified that certain payments reflected in the records weren't actually payments, and they should have been given credits for that money. The problem is severalfold. One, it was a lay witness giving opinion testimony.
Wasn't your position that the lay witness misinterpreted your data?
That is correct, Judge. So
that what they taught, where the lay witness said credit wasn't given, by way of example, there was a reference to a $60,000 payment you began early on in your brief, but the bottom line is your data, forget the color coding of everything, basically showed that all credits were given where appropriate.
correct, Judge, correct, because the way he interpreted it was as if those were credits against the contract price, but what they were was credits against the payments. And so if you actually remove those negative numbers from the total sum, the number would have only gone up, it wouldn't have gone down.
Counsel, if we agree with your initial argument that you can't have a mechanics lien if there's no money owing from the owner, then we don't get to any of the other arguments.
That is correct, Your Honor.
You say at page 4 of your brief, thus the lien fund available to respondent was no more than $18,810.50. Where does that go? Because you're certainly not conceding that you're on the hook for the $18,000.
Correct, Your Honor. So even if we ignored the fact of the failure to show that the owner owed money to the general contractor, when you do the simple math between J.T. Megan and Nastasi, you're left with $18,000 at
That
most.
Supreme Court got the number wrong by hundreds of thousands of dollars. By Supreme Court's reasoning, you should only have gotten to $18,000.
Correct, that is correct.
Do you want to address the diversion of trust funds argument?
Sure, Your Honor. What the lower court did here is conflate Articles 2 and Articles 3A of the lien law. They are separate and distinct remedies under the law. In fact, they are sort of...
That wasn't pleaded, right? That was just, there was an amendment of the pleadings to conform to the proof.
Correct, and that was correct. That was, at one point, it was only asserted as against Nastasi. It wasn't asserted as against J.T. Megan, and there was no allegation that J.T. Megan actually even had knowledge that it received these alleged diverted funds. There was no tracing done. There wasn't a forensic accountant provided at trial. And what the court did is actually conflate Articles 2 and 3A. What she said is, well, to the extent that the payments can be better characterized as a trust diversion, then she conformed the pleadings to the proof. But her next sentence said, accordingly, CAMCO's lien is therefore valid. But that is a complete error of the law. In fact, Articles 3A and 3 are somewhat mutually exclusive, because if you had to have a valid lien claim, you have to show that there is money due and owing to the tiers above you. To have a trust diversion claim, you'd have to show that the person above you had actually been paid the money and then thereafter diverted it. And that diversion claim they may have had a diversion claim as against Nastasi. We don't know what they did with the money because it wasn't shown at trial, but they settled their case with Nastasi.
Thank you.
Thank you, Your Honor.
May it please the court, my name is Marshall Stern.
Counsel, what's incorrect about the argument opposing counsel is making that if there's no money due and owing from the owner, then there cannot be a mechanics lien as a matter of law, therefore entitling them to a directed verdict?
Your Honor, the judge below, Judge Maisley, cited the matter of Perry Formworks, which which is a second department case, which has been followed fairly extensively in the
Right, and
first
I'm
department.
looking at a quote from Perry: "No individual mechanics lien can exceed the amount owed by the owner to the general contractor at the time of the filing of the lien." That statement of the law in Perry supports opposing counsel's argument that if there's not any money owed, there's nothing to support the mechanics lien.
Your Honor, the Camco lien was filed in April 29th, and 3 days later, the lien was bonded by J.T. Megan using a bond from Liberty Mutual Insurance
What does
Company.
that have to do with whether the owner owed money to them at the time? The fact that they bonded the lien doesn't prove that money was owed at that time that they bonded the lien.
Well, Your Honor, the job was not completed, and the owner owed money to.
Was there actual proof submitted at this trial that at the time the lien was filed, the owner owed money to the general contractor? Is there any proof in the record establishing that?
I believe it was, Your Honor.
Where in the record does it?
Judge Maisley dismissed my.
No, I'm asking you, you've submitted a record on appeal, and we have to look at the record
Right.
to support your assertion. So where in the record is there evidence that money was owed by the owner to the general contractor?
Your Honor, it's a matter of common sense
So
here.
your common sense is that if there was a bond, that meant that there was money owed. Is that your common sense?
That's correct, yes.
So the mere fact that there was a bond, that meant that money was owed.
That is correct, yes.
How, to pick up on the second point about diversion of trust funds, how do you conform the pleadings to the proof to allege a diversion of trust funds? There was no discovery on that issue. The case wasn't tried on that basis. Camco is involved in 26 projects with Natasi. Was there any tracing of the funds, which funds were for which project? How do you decide what funds are being diverted from this trust fund?
Your Honor, we were able to trace the the $2 million that Nastasi received from J.T. Megan, and then turned around and gave them four $500,000 payments immediately after receiving.
That case was settled, right? But how does that show that there's a diversion of a trust fund related to this? I mean, there are all these other projects going on.
Well, Your Honor, each project was given a different number by J.T. Megan and Nastasi, and that's how we followed the money.
What about the statute of limitations argument? Even if there was merit to the claim, how do you get around that there's a one-year statute of limitations for diversion of trust fund claim?
I'm sorry, Your Honor, could you say that again?
How do you get around the fact that there's a one-year statute of limitations for diversion of trust fund claim? Why wouldn't it be barred by the statute of limitations?
It's not barred by the statute of limitations because we started the litigation timely.
You started the litigation 1 year after the allegation that the trust fund was diverted? And
Well, we started the litigation approximately 3 months after the lien was filed.
When did you move, we're talking about the claim of trust fund diversion.
wasn't that only amended at trial? Wasn't it only at trial that you got granted leave to assert the claim for trust fund diversion? So that's when that claim was asserted, at the trial.
Well, it was part of the original pleadings that there was trust fund violations.
So then why was it necessary to move to conform the pleadings to the proof in order to assert that claim?
That's typical, what I do at the end of a trial is to conform the pleadings to the proof.
Thank you.
Thank you.
Your Honor, just quickly on
So
the,
what's your response to his assertion about the diversion of trust funds, that it was asserted in the original complaint?
yeah, what they asserted it against Nastasi only, and then they settled their case about a week or so before the trial. And so they had no diversion
There
claim.
was no diversion of trust fund claim asserted against your client at the time the trial began.
That's correct, Your Honor. And there wasn't even any evidence produced that he would have to show that my client not only received the diverted trust funds, which they didn't do because they didn't do any tracing, they'd have to show that J.T. Megan knowingly received diverted trust funds. And there was zero evidence established that.
Right, so if it was dismissed against Nastasi, what was there discovery or documents, et cetera, as to your client in terms of the diversion?
No, Your Honor. I mean, there were he certified checks. That was what they showed, that we had received payments, loan repayments from Nastasi, but that was it. He didn't trace the money at all. And the counsel refers to job numbers. Those job numbers are on the checks from the payments that my client issued to Nastasi in connection with the project.
But it's
There's nothing.
academic anyhow, because we're talking about the statute of limitations, and that would have occurred at trial in terms of the
Correct.
assertion of the claim.
Correct. That is correct, Your Honor. Thank you.
People v. Jamar Carr. Oh, you have 2 minutes, I'm sorry.
Your Honor, the $2 million of trust fund monies, there was no notice of lending, and there was no assignment of any of these.
But counsel, the thing of it is that if that claim was only asserted against Nastasi and was not asserted against J.T. Megan, then we have an issue as to the statute of limitations, because that would mean that the statute of limitations had run. The 1-year statute ran.
The statute, Your Honor, is to bring an action for trust fund violations. Whoever receives the money, that comes later.
Well,
You have to start a trust.
Don't you have to allege who improperly received the monies?
Not for the 1-year statute of limitations. You have to prove that there was a trust fund and that there was a trust fund violation. That only comes out after discovery. The 1-year statute of limitations doesn't start right away.
Well, we're at trial now, so when is the trial the discovery?
I understand that, Your Honor, but during the course of discovery, we discovered the $2 million for $500,000 payments that were made. We didn't know, we had no knowledge of that prior to the litigation commencing. We couldn't allege that J.T. Megan, we couldn't have alleged that J.T. Megan took the money. We didn't know that J.T. Megan took the money. All we know is that Nastasi didn't pay the money. And so now we have a judgment against Nastasi, and theoretically, we can go after everybody that was the beneficiary of those trust fund monies. There's no 1-year statute of limitation to bring that. The 1-year statute of limitation is to start a trust fund action.
Thank you. People v. Jamar Carr, excuse me.
May it please the court, this is David Richards from Kramer Levin of Tallis and Frankel, pro bono counsel for the Legal Aid Society, representing Jamar Carr on his appeal. Your Honors, this sentence is excessive. Mr. Carr's 15-year sentence is far too much. This offense was an anomaly, and he is not likely to reoffend again. He is not likely to do anything like what he had done before. Mr. Carr was 19 years old when he committed this offense.
So he robbed a bodega cashier at gunpoint. He shot the cashier. Cashier didn't die. Tried to shoot a bystander who attempted to intervene. And then when the police pursued him, he pointed his gun at the police officers.
I am not minimizing the severity of this offense in any way. But Mr. Carr, again, was 19 years old. He received a 15-year sentence. No one died in this offense, and I am not in any way minimizing the severity. But someone could get 5 years.
We have at least 3 people who could have died, right? I mean, we have a cashier who's doing his or her job, and then we have a bystander who's trying to intervene. I mean,
Well, respectfully, I would point out that on manslaughter 1, you could get 5 years if you had actually killed someone in this situation. No one died in this situation, and he received 15 years. And I would go further to say he was 19 years old at the time of this offense. This person had an unimaginably difficult childhood. This person had mental health issues that were a natural product of that childhood.
Were these situations that your client had, that the defendant had been undergoing in his upbringing, considered by the prosecution and by the court in the plea that he was offered and in the sentence that he received?
Well, there's nothing on the record that suggests that. Of course, we are to assume that this was all considered in that sentence. However, these mitigating factors were not considered adequately, and we know that because he received a 15-year sentence.
no, we don't. Well, I don't know that we can make that assumption. I mean, there's normally a pre-pleading report, a pre-sentence report, and I didn't have an opportunity to look at the pre-sentence report, but there was a forensic psychological evaluation of the defendant prior to his plea, as well as the pre-sentence report prior to sentencing. And so apparently the sentencing court was fully aware of all of the circumstances that you have pointed to in terms of his upbringing, his his suffering from mental illness, because we have the psychological evaluation.
Sorry for any misunderstanding with that, Your Honor. Certainly that was before the court. To the extent that there's actual textual and explicit recognition of those factors in determining the sentence, there is not.
Well, that would have been prepared by the defense attorney, so I'm sure that the defense attorney would have ensured that there was a thorough psychological evaluation.
And certainly there was, and that analysis shows that this person had a tremendously difficult life, a tremendously difficult childhood. By the age of 19, they were in and out of school with a horrible upbringing. Their father, who wasn't even their father, beat them mercilessly until they were 13. Then they get out of the house with their mother, who flees from this man, who she had to call the police on to save their child.
So what do you believe would be an appropriate sentence? I mean, given what he was facing, that would be 3 counts of, 3 counts of attempted murder, right? So one count of attempted murder in the second, they charged him with rob 1, and he pled to attempt murder in the second.
He was charged with attempt murder 1.
Right. Yeah, he's charged with attempt murder 1 because of the police pointing the gun at the police officer. So what do you believe under the circumstances would be an appropriate sentence?
Under these circumstances, for this defendant, given his age, given the mental health issues here, given what he has done since, and given the family support that he has waiting for him, a loving wife now, he is 24 years old, he is not a teenager, he is becoming a man, and he is doing everything he can to fix himself. Under these circumstances, in this case, with this defendant, the proper sentence is 7 years, with 5 more years of post-supervised release. That is plenty of time to deter. That is plenty of time to punish for this. He is being rehabilitated. He is trying to do everything he can to make himself better. You cannot ask more from him. And he, with 2 more years, he has a runway into parole, which will provide additional supervision, additional structure for him so that he can live a life that is productive and rehabilitated for the people that love him, and so that he can support them and they can support him. He is loved and he should be out.
Thank you. So, counsel, I'm assuming he had no priors?
He had no prior adult criminal convictions, no, Your Honor. The pre-sentence report did note a juvenile delinquency for grand larceny, though.
I missed the last thing you said.
On the pre-sentence report noted a juvenile delinquency adjudication for grand larceny. It's in the pre-sentence report, but there was no adult criminal convictions.
So how much time is he actually facing for these 3 offenses?
So, Your Honor, I just want to clarify real quickly. The 2 top counts were attempted first-degree murder, and that's for shooting the clerk in the chest and then attempting to shoot the Good Samaritan. He was charged separately for a different crime for the pointing the gun at the police officer.
But he pled guilty to the attempt murder in the second degree and the robbery in the first, right?
Correct, yes. And
People agreed to let him plead to a lesser charge because the charge was attempt murder 1, and the people agreed to take it to attempt murder 2. Is that what happened?
correct, Your Honor. The 2 counts of attempt murder 1, he was facing at minimum a life sentence. In light of that, the people and the court agreed to this specific plea deal where he was able to plead down to the attempted murder 2, where there was no possibility that he would face a life sentence, which is where we get the 15-year determinant from.
And what's the sentence range on attempt murder 2?
I believe it's 5 to 25, 5 to 15, or 5 to 25.
5 to
On the attempt murder, yeah.
And a minimum sentence under that guideline is just not appropriate here, as Your Honor's noted about the type of crime involved and then the aggregating factors. This at first was an armed robbery. He did not need to shoot or attempt to shoot 2 people to accomplish this crime, but he did shoot the clerk directly in the chest. There's also 2 victims of attempted murder, and he also threatened police officers with a gun when he was trying to escape. Given those facts, we think that the 15-year sentence is entirely appropriate. I would also just like to quickly note there was an oral and written waiver of appeal in this case. Unless Your Honors have any further questions, we would ask that you affirm.
Thank you.
Thank you.
Your Honors, I just have a few notes to make. One is, Mr. Carr took responsibility for this very quickly. Between the plea and the indictment was less than a year. He has since rehabilitated himself. At the time of the offense, he was on a tremendous amount of substances. He was on Xanax, Percocet. He was not in good shape. It happened over the holidays. It was an anomalous period where he was on an anomalous amount of substance. He had mental health issues that were troubling him from his childhood. He has taken steps to correct these things. He has effectively put himself through rehab. He has gone through Narcotics Anonymous, Alcoholics Anonymous. He has done 2 violence programs. He is doing everything now that he is an adult. He is doing everything that he can to fix himself and to make a brighter future for himself. He likes these programs so much that he is applying to become a counselor for those programs, for the program Exodus, so that he can help people like him who never received counseling beforehand to live a better life and to transition back and become good and productive people in society. He has one ticket in 5 years as a 19-year-old in prison. He is doing everything. Nothing more can be asked of him right now. And at 24, he is a different person than he was when he was 19. And by the time he gets out on 7 years, he will be a very, very different person. He will be a man, and he is trying to take ownership of his life. And since he has become a man and grown into a man, he has made every right decision that he could possibly make.
Thank you. And also, please thank your firm for allowing you to proceed with this case pro bono. Thank you very much.
Thank you.
Thank you both. Banks v. New York City Transit Authority.
May it please the court, my name is Vanessa Corchia with the law firm Armienti, DeBellis, and Roden. We represent MTA Bus Company in this matter. In this case, MTA Bus Company was not served with the summons and complaint. More than 2 years later, plaintiff moved seeking to compel an answer by MTA Bus Company or for a default. However, plaintiff's own affidavit of service establishes.
What happened here at the end is that MTA Bus Company was served at Livingston Street. And where
Allegedly.
they do not have an office.
Correct.
And MTA was served at Broadway, which may have been okay for that, although they probably also have an office at Livingston Street.
MTA,
But MTA BC was only served at Livingston Street.
right, because MTA was a separate defendant, and it is noted on a copy of the document that the summons and complaint was received only on behalf of MTA.
So it said accepted for MTA only.
Correct. So this was known at the outset of the litigation. By the time plaintiff moved, interestingly, you'll see the motion, the first branch of relief was to compel an answer by MTA Bus Company. The second branch was for a default.
So the court said that MTA Bus Company was aware of plaintiff's claims, had the benefit of representation in the litigation by its counsel, because apparently counsel represented both MTA and MTA Bus Company, right?
I'm sorry, go ahead.
But is that not correct? Didn't counsel
They
represent both?
represented, because a prerequisite to the lawsuit is a pre-suit claim.
Okay, well, the court said that, again, MTA Bus Company was aware of the claims, had the benefit of representation in the litigation by its counsel. Also, that MTA Bus Company was served, according to the court, the record showed that MTA Bus Company was served with a summons and complaint because it delivered to a person authorized to accept service at 2 Broadway. And so therefore, it said that there was no prejudice to MTA Bus Company by accepting the summons and complaint.
Yes, but all of that is incorrect, Your Honor.
Because there was no compliance with the CPLR for the process server to properly describe who
Of course,
was authorized, and
process server.
and we have no information as to whether the person who received the papers at Broadway was a duly authorized person who accepts service on behalf of the bus company.
Right, the identity of the person who received service or a description of the individual who received service, right?
Right, the affidavit of service did not identify the recipient by either name or description. But what we do know, and which is admitted by counsel for plaintiff, is that 130 Livingston is where the offices of New York City Transit Authority is located. So that's admitted. So you can't go to Transit Authority's office. Now, they were a defendant, although subsequently the action was discontinued against them. They were a defendant, and that was their principal place of business.
So, counsel, do we even look to prejudice, the fact that MTA Bus Company was in no way prejudiced because you were fully aware of the litigation?
It's not about prejudice, Your Honor. This is about jurisdiction. And here, let me be clear. When you say MTA Bus Company knew, how did they know? They didn't know. We knew because at some point, because originally we represented them with regard to the pre-suit proceedings. Because as the court is aware, first there has to be a pre-suit claim and then a statutory hearing, because there are certain prerequisites to a lawsuit.
Right, and that's what the court stated. I guess to some extent, the court was saying, no prejudice, you knew what was going on. You have time on rebuttal. Thank you.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. Andrea Borden for the respondent, Damon Banks.
I have a question.
Yes.
Does the knowledge of the attorney, should that knowledge be imputed to the client? In this case, MTA Bus Company?
My answer to that is that MTA Bus Company was served at 2 Broadway, and that the affidavit of service represents an omission or an error, and defendants cite in their own papers that failure to comply with 306 is not a jurisdictional defect. We don't have a jurisdictional defect here because we served MTA with the papers that also said MTA Bus. They both accept service at the same exact place. The service for both
Doesn't it
is
say
at,
accepted for MTA only?
but it's the same place at the loading dock at 2 Broadway.
Didn't it make it very clear, whoever was accepting it, that they were only accepting it for MTA, not for MTA Bus Company?
And the problem, if this court is at all...
So you knew that service hadn't been acknowledged by the defendant?
Well, something that is not part of the record, but I provided to the defendant this morning, and that I believe the lower court may have relied on, and I would ask this court to rely on, is that a week after we served the process on MTA at 2 Broadway, we received a notice to preserve evidence from MTA Bus Company, not from MTA Bus, not from MTA themselves, from MTA Bus Company. It has the new index number that was just served on them the week earlier.
First of all, we can't consider things outside of the record. And again, knowledge is not the standard. It is a jurisdictional issue. You have to show you served them, not that they knew that the lawsuit existed.
And so to the extent this court thinks there may be a jurisdictional issue, wouldn't the best approach be to remand it to the lower court for a traverse hearing to determine if service was proper? I understand that there are
Where's your
irregularities.
evidence that raises, to have a traverse hearing, you have to show a triable issue of fact.
Supported by the record.
What is the triable issue of fact you have generated? The only affidavit of service on the Broadway location says accepted by MTA only. So what is there to have a traverse about?
Because it was served at 2 Broadway, and the papers say both MTA and MTA Bus, and the place for service is the exact same.
But your affidavit of service says that MTA Bus Company was served at 130 Livingston.
Which I suggest is an error.
But that has not been corrected.
That doesn't constitute a jurisdictional defect. That's an error in the process.
So your affidavit of service says that a service was completed at 130 Livingston Street, right?
Yes.
And we have a stamp that says that service was accepted for MTA only.
We have a stamp that says that.
So given those two things, how then would there be a basis for a traverse hearing? And how then would it lead to any conclusion other than it's jurisdictional and there wasn't proper service?
Well, as I mentioned earlier, their counsel did serve us with a demand to preserve within a week of that service at 2 Broadway.
It's outside the record. It's totally outside the record.
How do you get over the compliance with CPLR 311A1? Like, we have this authorized person that you claim was receiving it on behalf of the bus company at 2 Broadway.
Correct.
But there's nothing about that person that we would normally see in an affidavit.
There is nothing about that person. I agree. I concede that in the affidavit of service.
That's not an error. That's not like, a scrivener's error or a typo. That's a total gap. Because usually when you serve someone of suitable age of discretion or serve someone who's authorized, you usually get certain information. The person was...
Correct.
The usual bells and whistles.
And I concede that. And I concede that there are omissions in the affidavit of service. But as defendants concede in their own papers, failure to comply with 306 is not a jurisdictional defect. I believe that 311A was properly adhered to, that service was proper where it was received at 2 Broadway. And I understand that it's not properly laid out in my affidavit of service, but again, that's not a jurisdictional defect. That is a question that I think should be addressed at a traverse, should this court be so inclined to overrule the lower court.
Thank you.
Thank you.
Did you still wish your time on rebuttal?
Your Honor, yes, I did. I reserved, I forget if it was a minute or two, but
A minute.
But I just wanted to say I would vehemently object to any attempt to enlarge the record by submitting any documents that were not in the record on appeal. And I also object to any assertion that there should be a traverse. The affidavit of service sets forth unequivocally that service was made on MTA Bus Company at 130 Livingston Street in Brooklyn. It's admitted that is not their address. That is not their principal place of business. You can't get up here and tell the court, oh, I guess that was a mistake. This is not the time to do it. There was not proper service. In fact, they were alerted that the only entity served was MTA Bus Company. They knew no answer had been interposed by MTA Bus Company, and then 2.5 years later, then they seek relief.
Thank you. Thank you both.
Thank you, Your Honor.